Okay, class. So this is my first attempt at a remote lecture for you folks. This lecture is going to be on operating under the influence in Massachusetts. Operating under the influence can be either operating under the influence of drugs or operating under the influence of alcohol. Those are two separate charges. Um, for the purposes of this lecture, most of what I say, unless I say otherwise, refers to either operating under the influence of drugs or alcohol. They're essentially the same elements in each offense. This is an important lecture because this is a very common crime in Massachusetts, and you're likely to come across it if you work for a practitioner. It's very it's everywhere, as we know. Okay, so there are three elements to operating under the influence, A, B, and C here on my outline, as you can see. The first element is operating a motor vehicle. The second element is on a public way, or a way to which the public has a way to which the public has access. And C, under the influence, and that can be either under the influence of alcohol or drugs. Okay, let's start with the element of operation. Operation, what does it mean to operate a motor vehicle? We all know what it means in a common sense fashion. We all know what driving a car is. We get in the car and we drive it down the street. And that is one definition of operating a motor vehicle. But it's not just driving. It's not just moving around in a vehicle. There's a case that goes back some ways, back to I don't remember, but anyway, here's a quote from the case that tells us what the definition is. A person operates a motor vehicle within the meaning of Chapter 90 when in the vehicle he intentionally does any act or makes any use of any mechanical, electrical agency which alone or in sequence will set in motion the motive power of that vehicle. This is old language. It's a little bit difficult to understand, but here's what it means in a practical sense. In Massachusetts, for example, it is not necessary that the vehicle be moving in order to be operating. The case law has held that a parked vehicle with the engine running is enough to show operation. All right. The case law has also held that a parked stationary vehicle, when the keys are in the ignition and it's turned to the on position, so that all the lights light up, that constitutes operation. Why? Because it's making use of a mechanical or electrical agency, which alone or in sequence will put the motive power, the motion power of that vehicle into play. So the reasoning here is that by putting the key into the ignition and turning it, it's setting into motion a sequence of events that will start operation of the vehicle, a sequence of mechanical events. And that sequence starts when you turn the key to the on position. And it obviously it continues when you start up the motor, and then it continues when you take the thing out of park and put it in drive. So, that's the basic operation definition of operation. Okay. The next element is public way, and I have in parentheses, or a way to which the public has access. All right, and I have a quote from some cases there. Essentially, a public way is what we think of as a public way. It is a street, it is a road, it is a highway, it is a lane, it is any place where cars, motor vehicles drive, okay? So that's the easy definition. But it's not just that. It also encompasses ways to which the public has access. What does that mean? That means any place where the public can go and does go is also a public way. So that means parking lots. That means, other things. Basically, parking lots is a good example. Okay. That means any place where the public is invited to have access. Okay. So here's the quote from one of the cases. It is the status of the way, not the status of the driver, which the statute defines. It is sufficient if the physical circumstances of the way are such that members of the public may reasonably conclude that it is open for travel to invitees or licensees. All right. So what does that mean? That means what it says. It means if it looks like a public way, if I'm driving around and I'm a reasonable driver and I look at an area and I see other drivers going in there and I see, for example, a store with cars parked outside the store, and I see an entrance to that parking lot with arrows. As a driver, I can reasonably conclude that it is a place where the public has a right of access, as invitees or licensees. And don't worry about that language. It's ancient language. It's not really out of favor now. Okay, so how do we determine what a public way is? It's common sense. What is a public way? They talk about streetlights, paving, curbing, abutting houses, businesses, crossroads, traffic, street signs, and hydrants. These are all manifestations of a public way. What I'm saying here may sound overly simplistic to you as to a public way. It seems like common sense that we know, but it gets as the litigation progressed, cases came along which pushed the boundaries of public way. Um, so, or actually contracted the boundaries of what a public way is. So, there are cases where somebody, for example, decides they're going to drive onto a ball field that's goes up over the curb and does donuts in a ball field drunk. That is not a public way. Clearly, a ball field is not a way to which the public has access in their motor vehicles. Obviously, they can walk there. Another example was a case where people were in Massachusetts. People were doing dirt biking in a big field, and they had dirt bikes, and they were drunk, and they're on dirt bikes, and somebody got killed. And that a case held that that was not a motor vehicle homicide because the person was not it was not a public way. There may have been other charges that the person was guilty of, but the charge of motor vehicle homicide by drunk driving rather was not present because that element is missing. So, okay, I've said enough about that. Under the influence. What does under the influence mean? Under the influence, number one, it says drunk versus under the influence. It includes people who are drunk. We know what drunk is. Drunk is commonly understood. Person is slurring his words, sloppy talk, falling down, staggering all over the place. Oh, he's clearly drunk. That is a person who is under the influence. But under the influence also means not just drunk. It encompasses more than that. Under the influence means even if you're not drunk, if you have consumed enough alcohol to diminish your capacity to drive safely, you are under the influence. You'll see public service announcements about buzzed driving. That's kind of what that means. It's about people who are not that visibly intoxicated, but as long as their consumption of alcohol diminishes even to the slightest bit their ability to drive safely, they are under the influence. So you don't have to be drunk to be convicted of the crime, and it's not drunk driving. That's people say it's drunk driving. It's driving under the influence. There is a difference. Okay. Number three, we're not required to prove that the defendant drove in an unsafe manner. We don't. It's not an element of the offense of operating under the influence to show that the defendant was weaving all over the road, that he was going over curbs. There are many drunk driving cases where a person is stopped for a motor vehicle violation, such as an inspection sticker or speeding or some minor offense, and is not driving in an unsafe manner, and he is convicted after field sobriety tests or breathalyzer evidence. Number four, a layperson can opine to the defendant's sobriety. This is just a point to make about proving under the influence. What does that mean? It just means that any one of us can get up on the stand in a trial and testify that the defendant appeared drunk to us or under the influence, either one. Okay, and we don't need an expert. That is different from drugs. In a situation of operating under the influence of drugs, that is required. Okay. Number five. Okay, there was a case that came down called Commonwealth versus Canty in the state of Massachusetts. This has to do with an officer testifying as to his opinion about the defendant's sobriety, which is permissible. An officer can get up on the stand in a trial, and after a number of questions from the DA, he can testify that, in his opinion, the defendant was under the influence. Remember, an officer, like anybody else, can offer that opinion. That is permissible opinion because alcohol is a common drug in our society, unlike other drugs, and everybody knows the effects of alcohol. Okay. What the officer cannot say, in his opinion, is he can't say that, in his opinion, the defendant was operating a motor vehicle under the influence of alcohol. Why is that? He can say that the defendant was under the influence, but he cannot say that the defendant was operating a motor vehicle under the influence of alcohol. That is because he is basically now taking the case away from the jury, and basically he's stating his opinion now that the defendant is actually guilty of the offense, because he has now basically put in all the elements of the offense, and he's basically saying he believes the defendant is guilty. So he is permitted to opine or give an opinion as to whether the defendant is under the influence, that one single element. He can't get into the other elements. Each of these elements must be separately proved and satisfied by the Commonwealth in order for the defendant to be found guilty. And the officer doesn't have any business in getting involved in those other elements. Those are for the jury to decide. Okay. Okay, here's a rule about drugs. What happens when you are charged with operating under the influence of alcohol? You take a breathalyzer test. The breathalyzer test reveals that your blood alcohol content is low. It's under the legal limit. It's 0.02 or 3. Okay. But you also have drugs in your system. You also have they also find out you've been smoking marijuana or whatever. Okay. If the government can, if the rule is that if the drugs combined with alcohol contributed to your inability to drive safely, then you are guilty of drunk driving. So in this case, in this example that I just gave you, where you are under the legal limit, but you have drugs in your system, if the government can prove that those drugs and alcohol combined made you unsafe to drive, and that the alcohol that's the case, then you are guilty of operating under the influence. Okay, so it doesn't the idea is the government shouldn't be required to figure out. It's not our job to figure out which one of these things made the dude intoxicated. If there's alcohol involved, if that is one of the causes of his unsafe driving, then he is guilty. Okay. All right. So I'm gonna stop there, and this is a test. I'm going to see how this goes. I'm going to then record another lecture, the rest of the lecture. Thank you.